Hello and welcome to the Rogers Brief for October 6th, 2023. I'm Adam Rogers. Thank you for watching and thank you for listening. Happy Thanksgiving weekend, everybody. Hope everybody gets a chance to get a good meal with family, friends, or at least a little bit of rest and relaxation on a long weekend. So, I want to talk about a few things this week. The main topics I'm going to cover are going to be a few trials that are ongoing in Nova Scotia. One is this Randy Riley jury trial that just wrapped up yesterday with a not guilty verdict. Really interesting. This is a retrial, a case that went all the way to the Supreme Court of Canada before coming back for retrial. And some interesting developments there. And Andrew Gnazdowsky, this is an engineer, tragically killed back in 2020 while trying to swim out to obtain a piece of equipment working on a Nova Scotia Power site. So the companies, Nova Scotia Power and a couple of engineering companies, are in provincial court charged under the Occupational Health and Safety Act. So we'll go through some of the arguments and some of the people involved there. And then nationally, there's an issue. One of the Freedom Convoy accused, Pat King, one of the more prominent of the people involved in the truckers convoy in Ottawa, his trial is going to get started next month in November. And there was an application to have the venue changed from Ottawa to some other venue outside of Ottawa. And so that application was heard this week. Don't have a decision on it yet, but I want to talk about that and just let you know where I think that's going to go. Before that, just a couple of updates. One update from last week. In the last week's video, which is still up, of course, for people that want to catch up on it, I talked about this harassment allegation down at in Sydney at CBRM. The fire chief, outgoing fire chief, made a complaint of harassment against 4 of councillors. We saw a report issued from a third-year associate at Stuart McKelvey, which showed that there was harassment, in her view, fairly low-level stuff, some email threads. Anyway, my view of it was that it probably wasn't worth taking it to that level, and I didn't think the report was all that thorough in a sense. Turns out that cost taxpayers of Cape Breton Regional Municipality $30,000, that situation. 18 of it for the report itself, and then another $12,000 in legal fees for some of the councillors who were able to get some of their legal fees paid as well. So just an update on that situation. The other thing, just to quickly cover, I see in Nova Scotia now the RCMP is instituting online police reports. So if you have a situation, and there's 4 of them, where it's mischief or damage to property or vehicles under $5,000, a hit and run of an unoccupied vehicle or property, again under $5,000, theft under $5,000 for including bicycles, thefts from vehicles, or lost property, including license plates and registration tags. So instead of going to the police station and submitting a report now, what the police want you to do is do an online report. Okay, so what's going on with that? I'd say 2 things. One is this is a way to save time and human resources on the police department's side, because they don't need to staff a detachment, especially smaller detachments that aren't always seem to be staffed. I know that's the case here in Guysborough sometimes. That you don't need to go, or you don't need to wait until there's somebody in. You can just file it online. But I think the other reason is these are going to be, I think the results are going to be twofold. One is there's going to be more of these reports, because it's a lot easier to just file a report online than it is to figure out where the detachment is, check out the hours, and physically go in and take that step of making the report in person. The second very predictable, I think, outcome of this is going to be that those reports are going to be ignored more often. So you submit an online report, you haven't met with a particular officer, you have nobody to talk to that you know is at least familiar with the case. You just submit online, somebody might get back to you. They might investigate. You don't know what's going to happen. It's like so many things these days where you just submit something and there's nobody on the other side that you know is dealing with it, and it could go nowhere. Who knows? So these lower level offenses or allegations, we'll see. We'll see how that develops over the next few months as this system rolls out. All right, so first story I want to talk about. This is a very interesting trial in Nova Scotia. Randy Riley, and it involves the murder of Chad Smith on October 23rd, 2010, so 13 years ago. And it was he was delivering pizza, and he was shot with a gunshot and killed. And so Randy Riley was charged with second-degree murder, and there were witnesses. A witness, Paul Smith, no relation to this deceased Chad Smith, claimed to have driven Randy Riley around, talked about some of the discussions they had, and that Randy Riley shot Chad Smith. Has since changed his story. Another witness was Caitlin Fuller. Caitlin Fuller also admitted to changing her story, but she was also in the witness protection program, because she said after the killings, the days after the killings, that Riley had threatened to kill her, and all these things. So she was in the witness protection program. Okay, we'll come back to all that. Randy Riley was represented by Trevor McGuigan, who is one of the top defense lawyers in the province these days, certainly. Trevor represented him at his original trial as well, and Randy Riley was convicted at that time, appealed to the Nova Scotia Court of Appeal, and there was a split decision, 2 judges in favor of upholding the conviction. One, Justice Scanlon, was in favor of overturning the decision and sending it back for trial, and adopted Trevor McGuigan's arguments at that point. So because it was a split decision on a criminal trial at the Court of Appeal level, there was an as of right appeal to the Supreme Court of Canada. Normally you need to get through some hoops, and the Supreme Court needs to grant leave to appeal, and they don't grant leave to appeal in many cases, but where there's a split decision at the appeal level, then they need to hear it. Well, the Supreme Court of Canada adopted the reasoning of Justice Scanlon, which I'll get to in a second, and ordered a new trial, and the new trial just took place. So we'll come around to some of the interesting details of that. So the issue with the first trial was this, he wasn't a co-accused, although he was tried separately for the murder. A gentleman by the name of Nathan Johnson was convicted in 2015 of first-degree murder of Chad Smith. First degree, that is planned murder. Right? Randy Riley was charged with second-degree murder, which is deliberate but unplanned. All right, so Nathan Johnson, Caitlin Fuller's boyfriend, by the way, was convicted. He had testified at the original trial that he did the job himself, that Randy Riley didn't do it. But the Crown asked the judge, and the judge, Justice Chipman, in the original trial, gave a warning to the jury that Nathan Johnson, was an unsavory witness, and they should be careful about assessing his credibility. This is not an uncommon kind of a warning. It has a name. It's called a Vetrovac warning, and it's something you do if the Crown calls a witness, or if there's a witness. Anyway, if there's a witness that is unsavory to the point where the judge feels the jury needs a warning about that evidence. So Justice Scanlon at the Court of Appeal said, well, you can do that if the evidence is going against the defendant, and it's a Crown witness. Well, it doesn't have to be a Crown witness. It's the matter of who's the evidence going against. if it's going against the defendant and is trying and is, would tend to convict the defendant otherwise, but the witness is unsavory, you give a warning. If the evidence is in favor of the defendant, as it was with Nathan Johnson's testimony that he did it himself, Randy Riley wasn't involved, then you shouldn't give a warning. You should just let the jury listen to it and make their own decisions. You don't add to the difficulties, add to the burden, in a sense, of the defendant. Because what it does is it gives the jury an unfair, it puts an unfair burden on the defendant to then put in evidence, which they're not obligated to do ordinarily, to counter this evidence that the judge has now said is probably unreliable through the Vetrovac warning. So it adds an unfair burden to the defendant to have that warning given by the judge. This is what the Court of Appeal said, and also what the Supreme Court of Canada agreed with. So they send it back to be retried. And at the retrial, so when they send it back for retrial, the Crown doesn't need to do the retrial. They could just withdraw the charges, but they went ahead with it here. And they put these individuals, the witnesses, Paul Smith and Caitlin Fuller, on the stand. So just kind of gold for a defense lawyer, because Paul Smith admitted to changing his story, admitted that he lied the first time around, or at least he had two different versions of the story. And Caitlin Fuller, she's in the witness protection program, and she has cost the witness protection program $634,000 over the years that she's been in there. And so she had a financial motivation to continue to, claim that she had been threatened by Randy Riley, and this sort of led to the presumption, if he threatened her after the fact, then that leads to the presumption that probably he did something and all this stuff. So she had a motivation to lie. The jury didn't take very long to make a decision. They took about 4 hours or so. This was, seems like they had very few doubts. So they come back Thursday morning. You get in, start court at 9:30. It takes some time to get through the sort of procedural stuff, and then the jury leaves the room to deliberate. So maybe they start at 10, a little after that. They gave their verdict at 2:30. So between a little bit of deliberation and lunch. Juries always have lunch. they never, even if they have a very quick decision, they always seem to make sure they get lunch. They took about 4 or 5 hours, very quick time for a jury to make a decision. So a very obvious decision in their minds, it seems. Tough one for Randy Riley. Okay, so here he has these unsavory witnesses, people that changed their stories or had motivations to lie. He was in jail. He was arrested and put in jail in 2013. Released on bail after the Supreme Court of Canada decision. He was released in March of 2021. So he was in jail for 7 years, 8 months. Incredibly long period of time. So I noticed Trevor McGuigan made a few comments afterwards that, to that effect, that's, yes, there's some justice done, but, he was in jail for a long time, so certainly not perfect. Don't know who the prosecutors were. They did not comment afterwards. Certainly didn't answer any questions as to why they proceeded with these charges. So maybe they will answer some questions, maybe not. I kind of doubt it. All right, so we'll see if there's any other fallout from that. Certainly there should be some answers on the Crown side as to why they continue to proceed with the trial in the face of what seems to be some obvious holes in their case. Okay, next thing I want to talk about. Andrew Gnazdowsky, engineer, 26 years old, died in Sheet Harbour back in 2020. He was working for a company called Brunswick Engineering. He was an engineer who was a subcontractor to Nova Scotia Power, doing some inspections or some work on a hydroelectric system in Sheet Harbour. And there was a lake there where there was a device in the middle of the lake. It was malfunctioning. It was scanning the water. And so Gnazdowsky went out to check on it and unfortunately drowned in the course of doing so. So there's and I know his sister Nicole has been advocating for him and for his memory and for some consequences to flow from this. So here we have now in the provincial court a charge not under the criminal code but under the Occupational Health and Safety Act in Nova Scotia. So the number of charges, all safety related, basically saying the company didn't have enough systems in place or provisions in place or policies in place to ensure the safety of the workers. So look back at this. So it's not quite a criminal charge. It's not a criminal code charge. There's no individuals being charged. It's the companies. 3 companies actually. So Brunswick Engineering, Nova Scotia Power is also charged, and then a third subcontractor, Gentech, Engineering. Alex Keaveney for the Crown, Brian Casey for Brunswick Engineering, lawyer for Brunswick Engineering, Stan McDonald representing Nova Scotia Power, Brad Proctor representing Gentech. So all very experienced, capable lawyers on every side of this case. Looking back through the Occupational Safety Act cases, and there's one from 2015 that shows some good guidance, and this is from Judge Ann Derrick, who's now in the Court of Appeal, but this was when she was on the provincial court. And Longard is the case. It's an electrical company doing some work in Bayers Lake, and Chris Boyle was an electrician who was killed at the time doing some work on a live system. And so Section 13 of the Occupational Health and Safety Act says companies need to take every precaution reasonable in the circumstances to provide such information, instruction, and supervision as is necessary for the health and safety of the employee. Some interesting aspects of this kind of a case. One, the companies, it's a strict liability offense. So if you don't have, if you're charged with not having a policy book and you don't have a policy book, well, that's it. That's charged. But there is a due diligence defense. So if you're charged with not having a safe work environment, not taking every precaution reasonable, the company can defend that by saying, well, we had policies in place, we did everything, and either the employee went off on their own and did something that was unauthorized, or it was just something that happened that was completely unpredictable, but we did everything we could to make sure things were safe. Well, in the case, in the Longard case, so the second relevant legal principle is that causation is not necessary. So you don't need to make a causal link between the offense, the lack of a policy, lack of a safety precaution, violation of the act. You don't need to make a connection between that and the harm done. So in this case with Gnazdowsky, Nova Scotia Power, Brunswick Engineering could be found liable for not having the proper policies in place, not doing everything they could to ensure safety. But the court might still find that it was Gnazdowsky's fault himself, that he decided to go out and swim into the water and try to retrieve this gear. Some of the arguments made by the companies were that they did, in fact, have training and policies in place. Training and instructions were given to the engineers, to the subcontractors, and there was no urgency to go out and get this piece of equipment. There was no rush, no need to go get it. Could have waited for somebody to come in with a boat and retrieve the equipment in a more safe manner. But previously, a supervisor from Brunswick Engineering had gone out to retrieve the equipment when it had previously malfunctioned. Now, that person went out with a life jacket on. Gnazdowsky didn't have one. He was a strong swimmer, but nevertheless. So there's some evidence in both directions. So training and instructions were given. There was no urgency to act, but there's no boat on site, no flotation device, no PFD on site, and no other safety equipment on site to help rescue somebody if they did engage in this kind of a retrieval mission. So we'll see where this goes with the Longard case from 2015, Judge Derrick at the time found the company guilty. They didn't have policy documents in place. They didn't have any of these procedures. They had experienced electricians, and that was sort of their defense. And in fact, the person, Boyle himself, was in the course of creating a safety manual for the company because they were starting to get bigger contracts, and so they felt they needed that level of safety policy implementation. Of course, Nova Scotia Power already has that kind of stuff. Brunswick Engineering seemed to have some, and then also relied on the Nova Scotia Power safety training and instructions. But anyway, we'll see what happens there. I wouldn't be surprised if the judge does find that there was some violations because the safety equipment wasn't on site, but also assign some fault to Gnazdowsky himself for going out without the necessary need to do so. All right, last thing I want to talk about. So they made just to get back to that. They had closing arguments this week, decision reserved, so we'll see when that comes out. That's probably going to be a decision within, I don't know if they've scheduled a decision time, but usually you get a few weeks or a month's time. So we'll wait for that one. Last story, this is a national, sort of national scope. This is to do with the Truckers Convoy. I've talked about Tamara Lynch and Chris Barber's trial. This is another individual, Pat King, who's sort of more of the firebrand leader, spokesperson, or attempted spokesperson for the truckers movement, the Freedom Convoy. So he is charged also, along separately, but the same kind of charges with counseling mischief, that is damage to property, disobeying a court order, and obstructing police activity. So same kind of sets of charges. He's made an application to move his trial from Ottawa. Under Section 599 of the Criminal Code, you can do this. His lawyer is Natasha Calvino, and the lawyer claims that Mr. King is too notorious in Ottawa to get a fair trial. Now, this is interesting in a number of senses. One is that some of the other defendants, including former Member of Parliament for the Ottawa area, Randy Hillier, have also made these applications and been denied. So Pat King is claiming to be more notorious in Ottawa than the former Member of Parliament for the area. So that's an interesting one. Judge doesn't seem like he's going to grant it. He did make some comments to that effect, but then is going to write a decision about it. But we can kind of see where it's going. It's going to be rejected. The judge noted in the course of the arguments that the concern with Mr. King is the social media and media coverage, and that's not going to be solved by moving it from Ottawa to a smaller town a little further away or wherever. If it's in Canada, people are going to be able to follow it on online and in the regular media. So that's not going to be solved by moving it outside of Ottawa. And that the real issue is the pool of potential jurors in Ottawa, and whether people that are in the jury pool have had contact with the Truckers Convoy, may have had bad dealings with them, or been affected directly by the sound or the noise or the disruption from the protest. So if that's the case, though, the judge can always deal with that during jury selection. You need 12 jurors, but you're going to pick from a pool of hundreds. Surely the judge will think that there be 12 jurors that are not personally affected or had not been personally affected by the convoy. So looking at Section 599 is not something that's used very often. It's very rare that trials get moved. There's some, when I was looking these up, there's a few examples. One where a police officer was killed and the defendant thought it was just too notorious in the area. That wasn't moved. One that was, and there's another one near Ottawa involving a soldier. And the issue there was they had a 2-hour drive each morning from the jail cell to the community where the trial was to be held. And the judge said, well, we can manage that side of things, maybe get you a more comfortable drive or get you a place to stay overnight, a few nights during the trial. Wasn't moved. And the notoriety is usually handled just during the jury selection process, so it's rare. But the reasons are to be able to make sure you get a fair and efficient trial, safety and security of any victims or witnesses or society. And then the second reason, which I don't think has ever been used, I don't know if it has, is if a competent authority has directed that a jury is not to be summoned. So if the government, if there's some sort of civil emergency and the government says you can't, we need these people, you can't pull them in for jury duty, then you can't have a jury trial and you have to move it, I guess. But the most important of those is fair trial and an impartial jury. So if you're in an area where somebody is just too notorious that there's no way they'll be able to get a fair jury, an impartial jury, then you can move the trial then. But it's rare, and it's not going to happen for Mr. King. So his trial is scheduled to start in late November, and this will be following that as well. I'm sure that'll get lots of attention when it starts. So, all right. So there's some cases from this week that I thought would be interesting to cover. The Randy Riley verdict, not guilty. Andrew Gnazdowsky closing arguments this week in the Occupational Health and Safety case, and the Pat King trial where he's trying to get that moved to a new location. So I hope everybody enjoys Thanksgiving weekend, and we'll be back next week with another episode. Do not believe that the Sunday night show is going to be going this week. We'll watch for the Sunday night social media feeds for that. And if anybody happens to be in the Valley, Annapolis Valley this weekend, keep an eye out for me on the roads. The Valley Harvest Marathon is on this weekend. I'll be doing the half marathon, 21-kilometer run from Wolfville out and around the area and back to the stadium. So if you're in the Valley, give a wave if you see me running past, and otherwise we'll see you next week. So thanks again for everybody for watching. Thanks for listening, and we'll see you next time.